My name is Vasu Abhiraman, Senior Policy Counsel at the ACLU of Georgia. First, we want to recognize where this bill has come from. Many of the most problematic provisions in this bill have been taken out, and we do recognize the folks who've worked on this bill and sponsor for taking out some of those most problematic provisions, namely those provisions that would seem to force campuses to recognize and support discriminatory groups. That has been taken out, and we do appreciate that. Also, the case that was just mentioned, we filed an amicus in that case in support of the students' rights at Georgia Gwinnett College. And we're also on the record opposing free speech zones on college campuses, given that any public area is an area of free expression. So we speak with investment and authority as a group that has defended free speech for over 100 years on this issue. So the part of this bill about getting rid of free speech zones, affirming that any public areas on campus are areas of free speech, we do agree with those. And the case that was just mentioned was about that, was about cabining a student's speech to a free speech zone when he was trying to speak about his religion in a public area of campus. So that's why we support that portion of the bill, and that's why we spoke out in favor of students' rights in these instances. In fact, we're on the record also supporting Turning Point USA, when they were trying to start a chapter on Arkansas State's campus, and were told that they couldn't get petition signatures in an area where they should have been able to get it. So again, we support areas of this bill. Some of the things that Senator Parent brought up are the areas where we have concerns. Essentially, what happens in vagueness stays in vagueness. What is a minor disruption? What is a loud or sustained disruption? I want to point out that the law already defines as a misdemeanor engaging in conduct or activity which may reasonably be expected to prevent or disrupt a lawful meeting, gathering, or procession. This is in OCGA 161134. What we would recommend here is to get rid of the stuff about louder sustained disruptions. No one has the same viewpoint on what that is, and perhaps take a belt and suspenders approach to what's already banned in the code. Again, you can't engage in conduct or expressive activity that can reasonably be expected to prevent or disrupt a lawful meeting, gathering, or procession. If you were to make this bill better, getting rid of that language, but leaving the language in about, and this is from lines 31 to 34, engaging in fighting, violent, or other unlawful behavior, or physically blocking or using threats of violence, have no issues with that language. But again, this louder sustained noise thing, we see many other areas in the law, for example, noise ordinances that define what is prohibited and what is allowed more specifically. Something quantitative is involved. You can hear it from 150 feet, something like that. This right here is a little too vague, and what are our concerns with vague provisions like that? They don't provide adequate notice of what is prohibited, and they can lead to arbitrary enforcement, kind of like the arbitrary enforcement that happens on college campuses with free speech zones and viewpoints that folks on campus and authorities on campus may or may not agree with. So again, there's part of this bill that we do support, but these vague provisions here do trouble us, given that they could have the unintended consequence of chilling free speech. Also want to point out in this bill, and again, there's duplicate language in this bill, so lines 78 and 79. It says, as long as a person's conduct is not unlawful and does not materially and substantially disrupt the functioning of the public institution of higher education. The issue we see here is that materially and substantially disrupts is defined on line 26 through 30, and then it's applied not to interfering with expressive activity, but to the general functioning of the public institution of higher education. I think as a technical drafting matter, that doesn't seem to make sense to so thoroughly define the term from 26 through 34, and then to apply it in 78 and 79 to a different context. I'm not sure if that makes sense drafting-wise, and I just wanted to point that part out. Finally, again, this bill is attempts to, at least the intent seems to be to protect free speech on college campuses, which we do agree with. It contains some great language, like in 66 through 67, where any such restrictions shall allow for members of the campus community to spontaneously and contemporaneously assemble. We believe in rights of spontaneous assembly. Also, that any person who wishes to engage, and this is line 77, shall be permitted to do so freely. And I just wanted to point out that another bill advanced through this committee, and in fact was voted out of the Senate, SB 171, that does not affirm the rights of spontaneous assembly or permits given freely to anyone who wishes to engage in a certain activity. We support the First Amendment, and we would just encourage every member of this body to be consistent when it comes to supporting the First Amendment. So this bill is not nearly as much of an issue as that other bill. And if you want to support this bill, I would just ask everyone here to consider what it means to stand up for the First Amendment on college campuses, and then to also advance a bill with onerous permitting provisions, racketeering applied to protesters, things like that. And with that, I'll be happy to take any questions.
You do have a question for Senator Parent?
Thank you, Mr. Chairman. Actually, the issue I was going to bring up was 171 and the bizarre conflicts and
I hear you, and I understand the
vague
argument,
language.
but let's try to stick to one bill at a time. The bill is still a different subject matter, so to be fair, let's try to stick with this bill.
Well,
You
no,
can
but
make
they're
those
both about
arguments.
protesting and free
I know,
speech,
but-
and it was kind of like, how on earth are we going to reconcile
But you'll be able to
these two
make
things?
those arguments on the floor of the
But
city.
they have to
Save
be
it,
looked
so
at.
we'll
Okay.
listen then.
All right. Anyway, my question is,
Thank you.
I just have to say, okay. My question is, as far as what I noticed seemed to be vague language, and actually there is unconstitutionally vague language in 171, in my estimation, given what's been decided in court cases in other states. This legislation, as I understand it, and I do remember it from a couple years ago, when it was more problematic, but I recall that it started out as model legislation from the American Legislative Exchange Council. And so my question is, as it relates to your testimony about vague definitions, which I share a concern about, have we seen court cases about this? Since I know it's model legislation, so I would assume it's cropped up in many places all over the country, or has it changed enough that you still mention a concern with the vagueness, and if we want it to stick, it's problematic to have vague definitions as it relates to First Amendment rights.
Right. Well, generally, in terms of vague definitions, I can bring up an 11th Circuit case, Henderson versus McMurray, especially when it talks about loud noises. The noise provisions in that case were upheld in terms of a specific definition about a noise that can be clearly heard inside an adjacent or nearby building by a person using his normal hearing faculties. The terms amplified and heard using normal hearing faculties. These are the kinds of terms that we would associate with something that is precise enough to actually pass muster under the First Amendment when it comes to the term loud.
Well, so what that brings up to me is, shouldn't we, if we do want to advance it, shouldn't we put in language that will pass constitutional muster as opposed to something that your organization might sue and get struck down?
We agree.
Okay. Thank you. We might be interested to see that language.
Sure. They won't have anything to do if they can't sue, though. Right.
They got plenty of work right down here at the Capitol, Mr. Chairman.
Be happy to be out of a job.
Any other questions from the committee? Was everything you had, Senator Parent? I don't want to cut you off, Senator Parent.
Oh, no, I'm fine.
Okay.
Thank you, Mr. Chairman.
Any other questions from the committee? All right, thank you.